Monteil against the Board of Inland Revenue.
Mr. Arts. Good morning, my lords. Once again, I am Barry Atz, and I lead my learned junior, Mr. Gale, and I'm instructed by Miss Chelsea John, who is before you, and also Mr. Gary Ramkasoon and Miss Victoria White, who were unable to make it today. Mr. Knox appears for the revenue, and he's instructed by Charles Russell Speechless. My lady and my lords, my speaking note is quite short, so I anticipate that my submissions really would not be any more than maybe an hour or so. So there will be plenty of time for questions. But against that background, I would like to ask for a brief indulgence to kind of contextualize why we're here today and why this matter is important. And it shouldn't really take me more than 10 minutes of that 1 hour to do so. So what I would ask is that, or what I'm intending to do, is to address the issues at the highest level without necessarily going into the documentation. I just want to just speak about the matter. And then thereafter, I will get into the meat of the matter. So, to put this appeal into context, why it's important. It's important because most of the citizens of Trinidad and Tobago are employees. And the government of Trinidad is the main employer in Trinidad. So everybody basically is interested in this decision because it speaks to the respective responsibilities of employers and employees in the regime. So even though Mr. Monteil is before you, he really just represents one of hundreds of thousands of people who are in a similar situation that want to know what their respective rights and obligations are insofar as emolument income is concerned and being responsible for certain administrative functions within that regime of quantifying it and so on. Now, against that background, it's important to note also why this forum is very important. We are on camera, but in Trinidad, at the Tax Appeal Board, these matters are in camera. People don't get to really see tax matters. And the cases aren't really published. And when they are published, the names of the respective parties aren't disclosed. Like you would see in this particular matter at first instance, if you were to look for it, it would be AOM versus the Board of Inland Revenue. It wouldn't be Mr. Monteil. And in addition to that, the various employer in there wouldn't even be listed. It's actually XYZ Limited as opposed to. Now this context will become relevant why I'm saying that later on. So there are two main cases right now that in Trinidad and Tobago dealing with the interrelationship between the PAYE regime and the self-assessment regime, so to speak, and the assessment provisions. There are two main cases. The two main cases are the Unilever case, which will be in the bundle, and we'll take you to that later on. But as I said, at a high level, I just want to set out the issues. There's the Unilever case, and there is this case. They both deal with benefits in kind, and whether in the particular circumstances, the funds received were benefits in kind. That was the key issue in both. But in the Unilever case, the difference in the Unilever case is that the revenue pursued the employer under the PAYE regime. In this case, the revenue pursued Mr. Monteil. Now, the question is, now, at first blush, the two cases seem to be different cases, because at first blush it would appear that either the employer or myself, representing the taxpayer in this case, are taking two opposing positions. But in reality, it's the same issue, really. And I want to explain why it's the same issue. Because in Unilever, we have a situation in which assessment is meant to take place within a 6-year period. And if not, you're basically statute barred from raising an assessment against the individual. So in Unilever, we had this scenario in which 7 years had passed and the underlying emolument earner had the underlying earner, the equivalent to Mr. Monteil, could no longer be assessed for additional tax based on emolument income. It was not possible because 7 years had passed. However, in that case, what happened is the employer was considered to be responsible for tax on an additional amount. So what was really paradoxical in the submission of the employer is how could it be, if PAYE is meant to be a mechanism for the collection of tax, if that is what it's meant to be, how could it be that the employer is responsible for potentially more tax than what the emolument earner is? It just seemed to be a bit of a paradox. So the argument in that case was, you are ignoring the assessment provisions. Now, I want to explain, the PAYE provisions are not subject to a limitation period in that sense. The assessment provisions are. So which is the reason why they were able to go after the employer in that circumstance. So when the argument was presented, this creates a paradox. You can't operate PAYE on its own. You have to do it within the context of the assessment provisions. They work together. That was the argument.
So in the argument in Unilever was that if the time for assessing the earner has expired, then necessarily the time for going against the employer for the PAYE has also expired.
Essentially.
Yes.
But it was ruled in that case that the submissions of the employer were wrong. Because what was stated is that when it comes to determining emolument income, it's an exclusive regime. You can go after the employer. It doesn't matter about the assessment provisions. That was what was held. So in the case before you, we have the flip side of that. We have now the situation, again dealing with BIKs, with benefits in kind. We're the same scenario. However, the revenue pursued Mr. Monteil directly and said, there's additional funds and we want it from you. So the question was posed, in the light of Unilever, but in Unilever, we were told in a similar circumstance, this is an exclusive regime dealing with computation of emoluments income. So how is it that you are able to ignore the PAYE provisions in this circumstance and go directly after Mr. Monteil? How can you apply the sections in such a fashion, particularly given the paramountcy that Unilever stated was the employer's obligation or responsibilities within this regime? That was the question. That's the question. So the answer essentially is, well, they are two separate situations, and we can do so. That essentially was the answer. So what we have then, if one looks at it, and I kind of refer this as what I call the crossroads of quantification, is when an auditor at the revenue is in the back room and they are questioning a matter of liability, and they're at this crossroads, they consider they have an absolute discretion to either pursue the employer under the PAYE regime or the employee. So Mr. Monteil's position is that absolute discretion doesn't exist. In fact, Mr. Monteil's position is to the effect of the reason why he is being pursued in this situation is because the government has an interest in the employer. And because of that, well, it wouldn't really be revenue to collect from itself. So therefore, that is the reason why they would pursue the emolument earner as in himself. Now, this isn't a case of judicial review. This is a case of statutory interpretation. The question here is whether the revenue's practice is a practice based on principle or is it based on expedience? And that is why the public of Trinidad and Tobago is interested in this decision. So now to get to the actual matter before us. How did we get here? Just so, again, some further context, there has been no trial. This was actually an appeal and a preliminary point. The notice of appeal is dated, and the notice of appeal is the pleadings, by the way. That's what they call it at the Tax Appeal Board level. So they were filed back in 2015. We're here today. Mr. Monteil is here today. You would know better than anybody else that there's not many tax cases that make it this far. In fact, as far as I understand, there's only 2 tax cases that have made it as far as the Judicial Committee, probably in the last 20 years or more from Trinidad and Tobago, and the last one was last week, last week Tuesday. And I believe you, Lord Richards, and Lady Rose, that you were both part of that. So, but no one really gets here. And we can understand why, because in the facts of this case, since this matter has progressed to today, Mr. Monteil's, the interest on this liability that's growing is of the nature of around 37 million at this point. 37 million. But Mr. Monteil had no choice but to come here because he was assessed at 12 million. So he had no choice. So right now we're at around 48 million. The various people in Trinidad and Tobago, the employees looking at this on camera, because it is not in camera, are very interested because it has implications for them in this situation. So there was no trial. There was a preliminary point. The preliminary point was, well, in fact, the preliminary point arises from 6 grounds of appeal in the notice of appeal, and now I will take you there, my lords. I invite you to look at page 6 of the electronic bundle. In fact, page 7 is, the various grounds are on starts page 6, but page 7 is really what I'd like to take you to. And paragraph 1E, which starts in the alternative. So, one of the grounds, it basically says, to the extent the respondent, or should I say, to the extent the revenue is of the opinion that the reimbursed income tax paid to the appellant in the amount of, it constitutes an emolument, and that the correct taxes have not been withheld or deducted, it is obliged, pursuant to section 99(1)(b) of the Income Tax Act, to serve a notice of its determination on his employer under the PAYE regime. That was one of the grounds. And this, again, is emanating from the Unilever decision that utilized this reasoning, that is this exclusive regime in these circumstances, and this is another benefit in kind case. So that's...
What does it mean, reimbursed income tax paid to the appellant?
The issue at trial will be whether the sum that Mr. Monteil had received from his employer is a benefit in kind or constitutes some reimbursed taxes from years before. He has other business interests, and I understand it was something to do with that, milady. But the real question is, I said that's an issue for trial, whether they're correct in it's a benefit in kind or whether it is something else. So, again, they have taken that this payment constitutes a benefit in kind that his employer paid. So, this was the question there, and this is what gave rise to the preliminary point. This is the genesis of the appeal. So it was really, is the revenue obliged to serve a determination under section 99(1)(b)? So against this background, I now want to take you to the statement of facts and issues, which is at page 17 of the electronic bundle. No, page 289, sorry.
So it's common ground on the facts that the sum that is being disputed is not a sum that was deducted from his salary by the employer, and it's not a sum that the revenue have received from anybody. That's right, is it?
Correct. They are saying that these sums received were not deducted. Tax was not deducted from them, and they were received by him from his employer, and that he's responsible to pay the taxation. Right. So paragraph 17 of the Statement of Facts and Issues, we have the two issues that are now before the court. So the first issue really concerns the concept of assessment. Now, let me just put a pin there. In income tax statutes, certainly in Trinidad, how it is considered, we note that there's 3 stages of tax, and this emanates from the Whitney case. That there's a declaration of liability, there's assessment of the liability, and there's recovery of that liability. So the first issue speaks to the stage 2 of Whitney, assessment of that liability. So it is concerned with the relationship between the assessment provisions and the PAYE provisions. Specifically, sections 99(1)A and 1B. It essentially asks whether an assessment in relation to emolument income can be valid if it ignores the emolument quantification and determination procedure set out in those provisions. That is what issue A is in relation to. Issue 2 deals with the concept of recovery, which is the stage 3 of Whitney. It basically asks, in the event the first question is answered in the negative, whether section 79(7) confers a right on the revenue to recover tax that has been assessed in respect of under-deducted emolument income tax from the employee directly as opposed to from his employer. Those are the two issues. One's dealing with assessment, validity of assessment, and one is the machinery in the act for recovery of taxes.
I think you said that B arises only if A is answered in the negative, but in fact, is that right? Or does it arise if A is answered in the affirmative?
Oh, sorry, I meant affirmative.
I think so.
Yeah, correct.
In other words, it's an additional string to your bow.
Correct.
Yes.
Right, that's correct, sorry. Yes. Thank you for that. So, to provide some further context, and this is addressed in the supplemental case. I won't take you there now, but it's addressed in the supplemental case at page 1069, so we could just maybe make a note of that at paragraphs 11 to 18. Dealing with the second issue, the recovery issue specifically. No party raised section 79(7) in its submissions before the Tax Appeal Board. No party raised it. Unfortunately, we don't have a copy of the transcript because, unfortunately, the practice of the Tax Appeal Board is not to give transcripts, even when requested. So I don't have that. But no party raised that at the Tax Appeal Board. No one. So Mr. Monteil had no choice but to appeal because it wasn't ventilated at first instance. The revenue had no choice, really, but to accept or to follow what was in the decision below, because if not, then the appeal would be allowed. So the revenue went along for the ride. But it wasn't the revenue's argument at first instance. So they adopted the logic. Now, having read, now at the level of the Privy Council, having read my learned friend's case at the electronic bundle, page 335, and paragraph 55, it appears that the respondent is no longer relying on section 79(7). Now, no doubt my friend will correct me if I have interpreted him incorrectly.
Well, I will deal with one of my submissions. I certainly don't say section 79 is relevant. It is highly relevant, but it's not the actual charging provision or the provision which authorises.
You say it's relevant as indicative of responsibility remaining on the employee, but it is not a charging provision in this case. Yes.
You said section 89, but I'll come to that.
Yes.
So, the issue, though, with section 79(7), to be specific, was on the facts of this case. The Tax Appeal Board said that the right of recovery was justified based on section 79(7). Now, the core facts are The taxpayer filed a return with his self-assessed liability. A number of years later, the revenue has said we think it is more and has assessed more, and says that after we have assessed more, Section 79(7) is what gives us the right to collect that tax. That is what the Tax Appeal Board held. So, this issue, then, issue number 2, arises from that. Now, even what my friend had said just now is not the same as what the Tax Appeal Board said. Right. So, given that he doesn't seem to be using that argument, that he's not agreeing with the with the Tax Appeal Board and the Court of Appeal on that point, from the perspective of the appellant, the residual issue remaining in this case is issue number 1, not issue number 2.
I'm not sure if that's right, because the issue 2 is in 2 parts. It's an either or, and it could be that the board might say, in relation to the question, was the appellant obliged by Section 79(7) to pay the amount in interest, he might answer that in the negative. Or was it instead the exclusive obligation of the employers? One might answer that also in the negative. So issue 2 is alive before us, because there are rather 2 questions involved in issue 2.
I'm guided, my lord. The primary focus of my submissions for oral submissions will be on issue number 1. We will address issue number 2, but the primary focus will be on issue number 1. So concerning this, Mr. Monteil's fundamental position remains that sections 99(1)(a) and 99(1)(b) operate as a discrete process in the Income Tax Act to quantify emolument income in situations that the quantum of an emolument is in dispute.
A distinct process under the Income Tax Act?
Yes.
Yes.
So in a sense...
Well, just finish, say again.
Okay, a discrete process to quantify emolument income in situations that the quantum of an emolument is in dispute. So similarly, as I said, the issue here is it a benefit in kind, as the same issue was in Unilever? Is it a benefit in kind? It's Mr. Monteil's position that there is a procedure set out in the Income Tax Act to determine that specifically, and that is sections 99(1)(a) and 99(1)(b). And it is Mr. Monteil's position that if you purport to do an assessment where you haven't fulfilled that process, the assessment is flawed and must be sent back. So, as I said, this is the matter of statutory interpretation. And I invite the court to weigh the competing positions of the parties here in light of what I refer to as the 3 Ps. The 3 Ps are principles of statutory interpretation, number 1. Number 2, proper construction of the Act. Here, we examine the absurdity my learned friend suggests exists if Mr. Monteil's interpretation is accepted. The short answer is that the Act deals with the fraudulent employee and the absconding insolvent employer and the issue of, I said, insolvency. So the absurdity doesn't exist. That's what we're saying at the short level. And we also examine the provisions in detail. And the third P is the practical effects of the revenue's position. In my respectful submission, the 3 Ps will demonstrate that Mr. Monteil's position should be preferred to that of the respondents. So dealing now with the first P, principles of statutory interpretation. These aren't really in dispute, and they seldom are. The question is always a matter of application. But let us deal briefly with the principles of statutory interpretation. Mr. Knox relies on Mangin and the Inland Revenue Commissioner case, which is at the electronic bundle, page 861. And this is consistent. I'm not going to take you to there right now, but as a note. And this is consistent with the leading case, or shall I say the oft-quoted case in Trinidad and Tobago, called Reynolds versus the Commissioner of Income, which is at the electronic bundle 949. So I'll start with Reynolds first, and now I invite you to go to the relevant portion. It is at the electronic bundle, page 299, at paragraph 20.
So what are we looking at?
Sorry, the Reynolds case at EB 299, paragraph 20.
I thought you gave us
You
9.
give us 949 as the page,
Right.
Which is indeed Reynolds.
which is Reynolds.
Oh, I think 299 is where it's referred to in your
in
written
my case. Well, if my lords and my lady don't mind, perhaps we can go to the paragraph in my case, because it's not the facts that are important, it's really the statement that is often quoted.
So it's 249.
299.
Yeah, 299 at paragraph 20. Right. So I'm just going to go to the first couple of sentences in the paragraph. In respect of statutory interpretation and what the purpose and goals is, we must look at the 4 corners to get the true intent and meaning of the ordinance. And the material part is, it must be read as a whole so as to correlate its several parts. Its language, when plain, must be given its full significance.
I was just trying to find where you are in that quote.
The first few lines.
Yeah, the first 3 lines.
Oh, yes, thank you. Yes, thank you.
Right. And similarly, the Mangin case is referred to in my friend's case at electronic bundle 331, paragraph 43, which I also invite you to read. So, the revenue, when it quotes Mangin, highlights where it says, thirdly, the object of the construction of a statute being to ascertain the will of the legislature, it may be presumed that neither injustice nor absurdity was intended. If, therefore, a literal interpretation would produce such a result, and the language admits of an interpretation which would avoid it, then such an interpretation may be adopted.
How far are these principles still the principles applicable in the construction of tax statutes? I mean, I'm looking, for example, at what Lord Donovan said under second. One has to look merely at what is clearly said. There is no room for any intendment. I'm not sure that that's altogether consonant with the way that taxing statutes are approached nowadays.
And, my lord, in reading jurisprudence outside of the territory of Trinidad and Tobago, we certainly are aware of the change. I was just mentioning that in Trinidad and Tobago, Reynolds is quoted every day.
All right. Fair enough. Thank you.
But in any event, the specifics aren't really going to even change in the submission I would submit in any event. The point, because I believe the core principle would likely be that one does look at what is said in any event. And obviously, if there's circumstances that suggest that what is said should be interpreted otherwise, well, then you can do so. But nonetheless, stage one is let's look at what is said. So we accept the third principle that my friend relies on, but respectfully submit that there is no reason to depart from the plain language where it is there. And this will be the subject of the second P, proper construction. If anything, in Mr. Monteil's respectful submission, it is the revenue's interpretation, not the appellant's, which produces absurd results. Those absurdities will be covered in the third P, practical effects. The third principle that was highlighted is not a license to imply sections into the legislation, as is clear from the second principle, and the qualification that the language must admit of another interpretation. And the second principle is, secondly, one has to look merely at what is clearly said. There is no room for any intendment. There's no equity about a tax. There's no presumption as to tax. Nothing is to be read in. Nothing is to be implied. Another principle, which I understand is trite law, but nonetheless, again, it's the application. It isn't whether it's trite law, and that's why we lawyers are in business. Is Benyon, which deals with the principles of statutory interpretation. And a principle of construction, which is critical in this appeal, is the general versus specific principle. In short, and Benyon is at electronic bundle page 1018. I'm not going to take
1018.
1018.
Thank you.
Yep. So in short, what it provides is, where the literal meaning of a general enactment covers a situation for which specific provision is made, it is presumed that the situation was intended to be dealt with by the specific provision. With that, I'll now move on to the second P, proper construction. The revenue says that Mr. Monteil's scheme would produce absurd results, as it leads to the result that even if an employee in his position negligently or in bad faith underdeclares his income by about 48 million, the revenue has no recourse against him personally to pay the tax due on this sum, even if in the meantime his employer has been wound up or made insolvent or disappeared, if an individual. And this is at electronic bundle 319. This is the cornerstone of the revenue's case. When one reads the revenue's case, this leads with this point. It starts at paragraph 3, and it is more or less repeated at paragraph 44, if I recall correctly. This is the theme underpinning all of the submissions. I submit respectfully, it is wrong. I will address the fraud and insolvency arguments first. The answer to the fraudulent circumstance is section 119 of the Income Tax Act. And I invite you to turn to page 492 of the electronic fund. 492. So, section 119 specifically addresses specifically addresses the circumstance where somebody knowingly or recklessly participates in basically making a false representation, declaration, the very circumstances that my learned friend mentions. And it says, I'm not going to go through it all, but it says, if you go to the next page, after it lists the various things, it says anyone who's involved in those things is guilty of an offence. This is on electronic bundle 493 now. Is guilty of an offence and liable on summary conviction. Now, I invite my lady and my lords to refer to page 494 of the electronic bundle. And this will be section 121 sub 2. This says, where a person is guilty of an offence under this Act, which therefore means 119, the court may, in addition to any penalty which it may impose, make an order for the immediate payment of any tax or for the penalty imposed, etc., etc. In other words, the situation that my friend speaks to is addressed.
And what about the case of negligence, which is one of the examples he gives?
So, in respect of negligence, what I would... Right.
Sorry, you answered my lord's question first. By all means, I have a question to follow.
Okay, no problem. The negligent employee aspect, I was going to address dealing with the concept of an under-declaration that my friend speaks to. Because when we go through the relevant provisions, I'm just giving you a high-level answer at this point. If we go through the relevant provisions dealing with the circumstances, it's very difficult for an employee to do a negligence declaration. And I will explain when we go through the relevant provisions. So that issue does not arise, which is likely the reason why Parliament did not put that as one of the consequences in this situation. But
can I just ask you about
sure.
121 sub 2?
Okay.
Okay.
Mm-hmm.
The court may, line 3, make an order for the immediate payment of any tax.
Mm-hmm.
Your case, as I understand it, is that leaving aside 1212, your taxpayer isn't liable for the tax, isn't liable to pay the tax. Are you saying that this imposes, creates an entitlement on the revenue to order payment of tax by a person found to have acted fraudulently, even if the tax isn't his tax due?
Correct. It says the courts may make an order as it sees fit, as it may consider fit. So anybody essentially involved in that process, the court has the ability to make an order to that effect.
But presumably there's something that stops them recovering the tax twice. So if both, say, the employer and the employee were prosecuted under Section 119, the court would order the totality of the tax to be paid by them in aggregate rather than both have to pay that tax. And there must be some limit on the amount. It has to be the tax that's due, presumably, doesn't it, under 1212?
One would certainly hope so, my lady. That's what I would say in that scenario. I would certainly hope so. I just know, what I'm just speaking to at this point is that the absurdity has been provided for. And the point really being that if the absurdity is provided for, we don't fall into the Mangin exception. So, dealing with insolvency, Mr. Knox also raises the what if the employer is insolvent hypothetical. Now, concerning this, the Act is also clear that under-deducted tax is treated as if it were the employer's own income tax. And Section 99(4) provides for this. And this is at Electronic Bundle 475. There is 94.
Which section?
Section 99, sub 4, my lady. I hope I gave you the right page reference. I did? Okay.
475, I think.
475, right. It's technology on my part is failing me. Okay, good. Right. So, it says if anyone fails to, and that person is the employer in this context, to deduct or withhold any amount required to be deducted or withheld by him under subsection 1 or lower, is guilty of an offence and right. Towards the last 5 lines or 6 lines at the bottom of this quote, it says, as if the same was tax payable by such person. And then towards the end it says, and the provisions of this Act relating to the collection and recovery of tax shall apply to the collection and recovery of any such sum or amount. Now,
In 4A and B are alternatives, so they may or may not have deducted or withheld the tax that they're required to deduct. But presumably, so how does that work if they've deducted the tax from the employee, but they've not remitted it to the board, then clearly they can be liable for that. But if they have not deducted it and not remitted it, then they can still be liable.
yes, my lady.
Are you going to go on and say that that's some kind of preferential liability in the insolvency?
I am going to get there. I'm going to get there, my lord. Now, but I wanted to, before I got there, I was going to point out that Justice of Appeal Raj Kumar placed emphasis on this provision in the Unilever decision. He emphasized it. And I just want to take you briefly there. I want to distract you, but I just want to take you briefly there. So at page 794 of the electronic bundle, 974, sorry.
Right.
At paragraph F. You can see the decision. In the decision, he bolds, italics, and underlines.
I'm sorry, I think I picked up a wrong page number.
Oh, 974.
Thank you, I did.
And it's paragraph 26F of the decision.
Yeah.
Right. And at paragraph 75 of the decision, which is at page 986, he kind of paraphrases the section. And he puts bolds at the end to basically say, again, it's almost a principal liability, the failure of the employer in this context. Saying as if it were in the same shoes, you could say, as the employee.
So which paragraph, sir?
Paragraph 75, my lord, on page 986. So,
Would he?
But that's presumably to give some kind of priority right in the liquidation of the employer, isn't it?
Yeah,
I
and
don't know, I'm guessing.
Yeah,
I
no,
don't know what the preferential regime is in Trinidad and Tobago.
and that is, sorry.
But he interprets the reference to tax payable by such person in 99(4) as being by the employee rather than by the employer.
Well, it could have been a typographical error.
Well,
because
that's what I'm wondering.
it could have been a
It
typo.
must be, surely.
Okay. Well, I saw it.
What do you say? Do you say that's, I mean, he's emboldened it, but you say actually the bit he's emboldened is wrong, that it should say...
No, I'll explain how I tried to, in respect of Justice of Appeal Raj Kumar, I wanted to assume that what he was trying to say, to be consistent with what he quoted before, what he was trying to say is the employer stands in the same shoes as, it's not just the fact that they have a responsibility to deduct, but at that point in time, they become the principal person liable for the tax. I was trying to reconcile it, but it could be a typographical error. The point being, what he said on page 974, he emphasized, which is exactly the language in the Act, that it's a tax. It gets treated like any other tax, is really the short point.
Yes, well, what he's doing is summarising 99(4)(b), and we can turn to the words of 99(4)(b) to see what it says.
Yes, right. So, and this is now leading to the point that you were just making there, Lord Briggs, is that once we get into the regime of collection, in that recovering collection, then section 111 will apply here. And 111 is the electronic bundle, page 484. So essentially, 111 says, and I will paraphrase in here, is that you could register this an amount as a certificate in the High Court. It gets treated like a judgment in that sense, and then every other remedy that you get in that circumstance will automatically flow. So that's now when we get to the Bankruptcy and Insolvency Act, which gives high priority to tax debts, essentially, which was the point that you knew I was getting to all along, Lord.
A pure guess, but I'm hoping to be given chapter and verse.
So the insolvent employer hypothetical is therefore also provided for in the Income Tax Act, is the short point.
Well, unless there's absolutely no money there.
Yes.
Right. But those protections in practice protect the revenue, provided, obviously, it doesn't delay for a number of years to get going.
Sorry, is the effect of section 111, subsection 2, it says, shall be treated as if the certificate were a judgment for the state obtained in the court for a debt. Are there other provisions, either in this Act or probably a different Act, which say that where the state has a judgment for a debt in its favour, that it gains priority in an insolvency for that amount? Is that what you're saying?
What I was saying is that Okay, well, perhaps I haven't joined the dots properly. Certainly, if you are put in the same shoes as if it is your principal liability, which essentially is what Justice of Appeal Raj Kumar was saying, then in the insolvency, it would be a tax debt because you are in the shoes of, it's being treated like it's your principal tax.
Right.
So therefore, to the state, it would be a high priority in an insolvency circumstance.
Where do we get that last bit from? That that makes it a high priority?
Oh, unfortunately, I don't have the excerpt from the Bankruptcy and Insolvency Act in our bundle.
Do you know what the provision in those acts are? Because I mean, it's rather important to your argument in answering the insolvency that you have a preference in the insolvency over other creditors.
My Lord, I certainly can come back to you on that because it is there. So perhaps one of my learned instructing counsel, hint, hint, will locate the provision for me.
But when it says you've got to register that, presumably if it's disputed, you can't get the certificate, or the certificate only comes if any dispute.
Well, it suggests that it's almost an automatic scenario. That's how I read this.
I mean, this is just one means of enforcement. This isn't the only means whereby the revenue can enforce amounts due to it. It can bring ordinary legal proceedings.
Correct. I just wanted to address the insolvencies, really.
I mean, all 99.4 read with 1111.1 and 2 does, as I see it, is simply to say, and if there's been an under-deduction and therefore underpayment by the employer, it can be recovered from the employer as if it's a judgment debt. I mean, it's quite a long-winded way of saying it, but that's what it seems to be saying.
That's what I couldn't say as well as you, my lord.
And that's not particularly surprising because it clearly is an obligation on the employer to pay a sum to the revenue. It's just a mechanism to give effect to that underlying obligation of the employer, isn't it?
Yeah, I'm seeking to address the absurdity. That's really where I'm coming from here. I'm seeking to address the absurdity that my friend suggests exists from the interpretation. The simple point being that there are remedies available for these various circumstances such that one does not have to interpret 99.1a or 99.1b in a manner to include something that's already been provided for.
But if I may say so far, it doesn't seem to me you've addressed what is said to be the absurdity in the respondent's case, which is, well, there is an obligation of the employer, but the employer may have been wound up or made insolvent. So as I understand, you've just shown us that there are mechanisms for the revenue to try to collect as a debt from the employer the sums which it should have deducted. But the point made in the respondent's case is, well, the employer may not have the resources to pay or may have been wound up.
Okay. So there are two approaches to answering that question. First of all, let us recall that there are two issues here. There is the validity of the assessment issue, and then there is the recovery issue. So the issue of whether or not you can ultimately collect and whether the provisions allow for certain situations, like what we're saying here, if the employer is insolvent, more speaks to the recovery. But right now, my focus is on issue number 2, which is the validity of the assessment. So if we're challenging the validity of the assessment, it is not an argument to say that about this is the insolvency. That is not an argument. It may be an argument in the second issue, but it's not an argument to the validity of the assessment.
Well, you have to look at the two together. I mean, the Whitney talks about 3 stages, and if there is a block to recovery in stage 3, that may be relevant to the assessment of whether, to the determination of whether the certificate is the only means of recovery, is the only means by which you can trigger recovery of tax rather than an assessment on the taxpayer.
I'm with you, my lord, but I suppose one of my responses to that would be non-resident withholding tax brings up the same issue, as an example. You could have the situation that the resident is insolvent.
Yes, but standing back, let us assume that the employer is insolvent and doesn't have the means to pay the tax which it failed to deduct. The net result would be that the employee receives gross income untaxed, and there is no remedy against him or her.
Now, I understand that
That's really the insolvency point, I think, that Monteil is putting.
Yeah, but I'm just putting to you what's in the respondent's case, but that clearly is what they're concerned about.
Yeah, I accept that there are outliers, my lord, but I'm saying the same outliers exist in withholding tax because it's the same situation. And also, even in the regular situation of corporation tax, the principal putative taxpayer could also be insolvent. So we certainly understand the outlier circumstances, but these do exist in the tax regime as a whole. So I don't know if that is a basis upon which to suggest that the appellant's interpretation is incorrect, given that it isn't just in this circumstance that this exists, this possibility. But I also, I also would like to draw reference to, I will draw reference to page 1012 of the electronic bundle, my lord. And this is emanating from the Whitney case. It is the decision of Lord Renbury. Now, I'm just using this for equivalent logic. I'm starting at the second sentence of paragraph 3. And he says, in relation to that particular, as again, the facts, I don't think the facts are important in this case. I just think the point that he's making is what is equivalent to this situation. Section 7 sub A 1 has imposed upon the special commissioners the duty of assessing the amount. Subsections 2 to 5 do no more than supply machinery for giving effect to subsection 1. But there are no words to the effect that if the machinery is inapplicable to the particular case, the duty in sub 1 shall fail to exist and shall not be performed. Now, the reason why I mention that, by analogy, is, again, in the context of Whitney Stage 2, specifically. It's not an answer to say that in an outlier case, you may not be able to collect. The logic being, you still have a duty. And in our circumstance, what we're saying is there is a duty pursuant to section 99, 1A and 1B. And we still need to address that.
But what is the equivalent duty that you're pointing to here? 99
1A and 99 1B.
This is the fact that the revenue is required. It says shall do certain things.
Correct. Now, the negligent, that was dealing with the insolvency point. Dealing with the negligent employee point, I will defer that to the third P, which is, I'm even forgetting my
Practical effects.
Effects, sorry. So I'll deal with that in that section. So, So now I want to, given that we've addressed, with the exception of the negligent employee, which I said we'll deal with later on, now that we've dealt with the main absurdities that my friend has suggested, which I submit are provided for in the legislation, now I want to apply the principles to the sections in the appeal. So, first of all, and this is where the Unilever case is important or relevant. In Unilever, and this is the electronic bundle, I'll take you to the specific reference in a moment.
Just before we move away from section 99, which I think you're about to do now, can I just ask you about section 9910, which is page 477, whether you want to say anything about that? Because that seems to say that where amounts have been deducted or withheld pursuant to section 99(1), when they're deducted or withheld, then the employee shall be deemed to have paid the same and shall thereupon cease to be liable for tax to the extent of the amount so deducted. So it seems to be looking at the underlying liability being liability to tax being one of the employee, where one mechanism for collecting that tax is PAYE under section 99, and to the extent that the revenue do manage to, where the employer does deduct or withhold the sum from the employee's remuneration, then that is treated as collection, leaving it between the revenue and the employer for the revenue to get that money in. But it says that the employee, because it's the person from whose emoluments they're deducted, shall cease to be liable for tax to the extent of the amount so deducted. So it's only to the extent that the amount has been deducted that the employee is treated as having paid the tax due on his emoluments.
I can address that, my lord. Okay, first of all, again, just so that we don't conflate, this is, the second issue, it's not the first issue. The first issue still remains the validity of the assessment, and 9910 doesn't speak to that. But 9910 speaks to recovery, so now I'll address that. So, in respect of 9910, it is clear that 9910 is in the context of 99.1. 99.1 is speaking of payments on account during the year the income is earned. So 99.1 is the PAYE equivalent section of general quarterly payments that normally exist in the self-assessment regime. That is the equivalent. And what 9910 is saying is that during the stage, the year of income, in that period of time, any amounts deducted, there can be a residual liability. Now, this really is the same issue as Section 79.7. It's really the same issue, because Section 79.7 recognizes that there is an obligation during the year of income to make up for a shortfall if there's a shortfall of your estimated liability. So we're not saying that doesn't exist. That's what Section 79 deals with. The issue that we have is the Section 79 applying the facts, because this is talking about an assessed liability after the fact, not your obligation to pay your self-assessed liability. What 9910 is speaking to is basically suggesting that if at the end of the year you believe you have more to pay, which is what Section 79.7 treats with, it is saying you deduct from what you are going to pay, what your employer has deducted, and the balance, if you think you need to pay it, you pay it. That is what that is speaking to. Again, that's not the circumstance that we are speaking of in this case. The circumstance we're speaking to in this case is not a stage 1 circumstance. The circumstance we're speaking to in this case is there a provision that's after assessment, after you disagree with what the emoluments are and you want to raise an assessment, what provision points you to that. And I'm saying Section 99 doesn't deal with that. I mean, Section 9910
is perfectly general. I mean, is it not a clear pointer to the fact that to the extent that the employer has not deducted, the employee remains liable?
He remains liable. Okay, maybe I should take you to Section 79.7.
Well, could I just press you a little on Section 9910? You said it's about collection, but surely it's about liability, isn't it? Because it says, when certain things happen, the employee shall thereupon cease to be liable for tax to the extent of the amount so deducted. So that's not about collection, that's about actual liability to tax.
Okay, my lord, let's step back, or in my respectful submission, let me submit how I interpret this for your consideration. Whitney has 3 stages: liability to tax, assessment, which is quantification of that liability, and then recovery of what was assessed. 3 stages. Nobody is saying that Mr. Monteil is not the putative taxpayer. Nobody is saying that. That's not our case. He's the putative taxpayer.
Putative, what do you mean?
What I mean by the putative taxpayer is, at the end of the day, is his income.
Yes, but you say he doesn't pay tax on it.
No. Well, again, this is on the recovery point. What we're talking about here is equivalent to the withholding tax context. Maybe that is clearer. Is that it's the non-residence tax.
No, I don't really. I think we'd be better sticking to the employee's tax,
Okay,
rather than trying to go into an analogy with withholding tax.
right. The point, the appellant's case is that there are some circumstances in the Income Tax Act whereby, even though you have the liability, that doesn't always mean you have to write the check. Right? So we know, for example, that 9910 99.1 is an example of that, whereby it's deducted at source. So the point that is being made by the appellant is, we understand that Mr. Monteil is the putative taxpayer. And we also understand, this is where Section 79.7 dovetails with this, we understand as well that if at the end of the year there's a shortfall between what has been deducted and what you estimate your liability to be, that you pay it. That's what Section 79.7
So it's only payable by the employee if he estimates it.
Correct. And again,
it's a slightly odd tax regime, that, isn't it?
Well, not. I would submit it is not odd in the sense that Parliament has intended certain responsibilities to be on the employer specifically, and it's permitted to decide who has the responsibility in a specific circumstance. This is not. At this point, I would like it to take you, in fact, to just show you how the regime works, which may seem strange, but it's consistent throughout the Act.
Before you do, I'm just struggling with the idea that someone can have a liability, but they don't have any obligation to pay the amount of that liability. I mean, the notion of a liability conceptually is it's something that the person under the liability has to pay. It's a very odd idea that A is under a liability, but they don't have to pay it. It's B who has to pay it, who is not under the liability.
But that is what the PAYE regime is.
Well, I'm not sure, because this says, shall thereupon cease to be liable to the extent of the amount so deducted. So where amounts haven't been deducted, he does not cease to be liable, he remains liable. But I'm trying to grapple with the idea of of the employee having a liability which they have no obligation to meet.
So the first answer that I would provide is, there is a liability to pay your self-estimated tax. Even in Whitney, what Whitney distinguishes, I just again to talk about Whitney. Whitney distinguishes.
So sorry to interrupt you, but so if an employee at the end of the tax year believes that his employer has not deducted enough tax, he, the employee, then pays that tax to the revenue. Is that what you're saying happens?
Section 79.7 deals with that.
That you say is the effect of that.
Yes.
So in those circumstances, the employee is liable,
To pay.
but only if he, the employee,
Correct.
estimates that too
Correct.
little has been deducted.
Correct.
That,
And
and
it is-
otherwise, the employee has no liability, even though too little has been deducted.
I'm not sure if I understood your question.
Well, Section 79.7 says that the employee or a taxpayer must pay any shortfall that the taxpayer estimates.
Yes.
So you accept, as I understand it, that if the employee estimates that the employer has deducted insufficient tax, then the employee must pay the balance.
Under Section 79.7, yes.
But that's only if the employee has estimated a shortfall, has identified a shortfall and
Correct.
estimated the amount.
Correct. And I
But
would,
otherwise, if in fact, or in law, the employer has deducted insufficient tax, but the employee does not identify that or estimate it, there is no liability on the employee to pay that.
I think 99.4 addresses that.
I see.
99.4.
Yeah, 99.4, I've taken you to that
But
previous.
that's the employer.
being guilty of an
That's the
offence.
Correct, because
So I see you're saying that section 9910, where it talks about ceasing to be liable to the extent of the amount so deducted, you say that is limited to an amount of underpaid tax estimated by the employee.
Yes.
Under section 79.7.
Yes. And my lord, I believe there's more clues to support that interpretation, which with your leave, I would like to take you to.
Can I just put you an alternative interpretation? You can deal with that as you go along, of 79.7, of the words, if any, as estimated by him. The subjection is an unconditional obligation to pay the remainder of the tax. But the amount which you have to pay at that stage, on or before the 30th of April in the next year, is dependent upon the employee's estimate.
Yes.
It's not saying he can get away scot-free, providing he makes up his mind not to make an estimate. He's got to pay it, but it's his job to estimate how much to pay. Not, he's only got to pay it if he makes an estimate.
I will consider.
It's the difference between making the estimate a condition of the liability to pay the shortfall and making the estimate the duty imposed upon him because there's a shortfall, so that he can quantify how much to pay by the date specified.
Well, again, in order to not put the provisions into conflict, where we have to understand that during the year of income, the employer has certain responsibilities and the employee, and Parliament has drafted a line between the two situations. So, generally speaking, if there's an under-deduction, it's the employer's responsibility. But what they're saying is it's a voluntary regime, and I can go to other provisions that are consistent with this. It's a voluntary provision. It's a voluntary regime insofar as the emolument earner is concerned. Their responsibility is if they think, then they can pay. And I could show you this even from the regulations. There's an example of it. Can I take you to Regulation 24, my lords and my lady?
I just wanted to understand what you mean by it's a voluntary regime so far as the employee is concerned.
Well, the whole
Are you saying that an employee is only liable to pay income tax to the extent that he thinks he ought to? Is that what you meant by that?
Even though I haven't phrased it exactly like that, essentially that is what I am saying here. I'm saying that the liability that is in Section 79.7 is a self-estimated liability. And 9910 is speaking to that same liability. it falls within that category because, again, it's within the same zone, which is during the year of income and making up a shortfall that you think that you have.
But if I may just put this to you, wouldn't that be a very strange tax regime? Most people don't like paying tax and have a very strong personal incentive to estimate the tax as low as possible, at least if they think they've got an arguable case to that effect.
Well, one has to also understand in Trinidad, which is also, and this is also departs from one of my friend's points, you don't have to file a tax return if you're an emolument earner. You don't even have to file a tax return.
But and you say if you decide not to file a tax return, then you can't be liable to any tax on your income.
No. I'm just saying one does not have to file a tax return in Trinidad and Tobago. So it isn't even to say that you have to do an estimate. I just wanted to make it clear that how things have been provided in Trinidad, it is clear from the system that they place a lot of responsibility in the employer, which is why a person in receipt of emolument income doesn't even have to file a tax return. I could show you.
But I mean that's because one hopes the system works pretty well, and that the deduction by the employer is indeed accurate, in which case no need for tax returns. It's all been dealt with. But we're dealing with a situation where the tax authorities say, well, that hasn't happened in this case, and indeed it's accepted that it hasn't happened in this case. And the question then arises, well, what's the effect of that?
Well, we're getting to the heart, I suppose, which is really in practical effects. We're getting to the heart of the issue that I'm probably going to deal with next, in terms of what the different responsibilities are. So if I may, get to that point, I will address these points when we get to the practical effects. But if I may also just take you to Regulation 24, because I just want to just also show a consistency in the regime. And this is our electronic bundle, page 564. Right, so 564. This is Regulation 24 sub 2. This provides for a situation that an employee complains that there hasn't been sufficient taxes deducted by the employer. And it says, and again, there's a whole procedure. If an employee doesn't think enough tax has been deducted, Section 23, it's on the page before, kind of explains you've got to do a complaint. Imagine that. The word is you have to complain to pay more tax if you're an employee. You complain to the revenue to say, my employer hasn't deducted enough tax. And the revenue has to be satisfied that you're correct after you complain that the employer has not deducted enough tax. So what it says in that scenario is that after you complain and they are satisfied that your complaint has merits, it says, in that circumstance,
well, 24 is concerned not with a complaint that not enough tax has been deducted, but with a complaint that too much has been deducted.
No, there's two provisions. The second provision is the opposite.
Is there a misprint in the anti-penultimate line of 24.2? Should he be aboard?
I submit, and my friend's case says the same thing, that he is the employer. And that's the point that I was going to make. My friend.
Suppose that you have two jobs, and they're both, you earn a small amount of money in both jobs, but if you aggregate them together, then you are bumped into a higher tax band. And both employers are deducting the basic rate of tax because that's the appropriate one if that's just your income. But you want one of them to deduct a higher rate so that overall, over the course of the year, you know you won't have a big tax bill to pay at the end of the year that you might not have saved up for. So presumably what you can do is say to the board, I want my second employer to deduct tax at a higher rate than is liable just on my salary from him, because I prefer to pay the tax as I go along. Is that the sort of situation that they're dealing with here?
Well, I'm not sure if that is the situation, because I would wonder in that circumstance why the employee wouldn't just say to the employer, deducted a higher rate of tax. Why do you need to go to the revenue?
May, and the employer may say, no, I can't be bothered. It doesn't fit with my payroll. Everybody gets just basic tax deducted because I don't pay anybody higher, and I'm not prepared to make the effort to change my payroll, suppose.
Okay.
Yeah. It's not a fanciful scenario, I wouldn't have thought. But is that what's being aimed at here, that sort of...
I submit that could probably be one of the scenarios that is being aimed at there. But, you know, it doesn't limit itself to a situation like that. Now, again, the point I wanted to make, which Lord Briggs, you had just picked up on, is it says, he shall, as soon as practical. That's what it says. It's exactly what it says. And in my friend's case, my friend, in referring to this section, says, my learned friend, my apologies, that he is the employer. And this is at paragraph 34 of my learned friend's case, page 327.
Very odd, because it's the board that's satisfied that there's been a deduction on a complaint by the employee. And there's nothing here about how the employer, if he is the employer, gets told that the board has accepted the complaint.
Right. So my lord.
I'm not saying you're wrong, it's just the whole thing seems rather odd.
So my lord, but I want to, before I address that point a bit further, maybe the other oddnesses in the regime, but it is the regime, is if we now compare it to the other circumstance in sub 1, in the situation that it is the reverse, the typo is not there, you will see. It says, the board, this is the last 3 lines, the board shall, as soon as practicable, cause the excess to be refunded to the employee or office holder. So, in one scenario, there's a direct relationship between the board and the employee. And in the other scenario, the board delegates it to the employer. Now, that is also consistent with section 91 of the Income Tax Act. You will also see a similar scenario in section 91 of the Income Tax Act, which I can take you to.
I'm just trying to... Sorry, just before we leave Regulation 24(2), that seems to be contemplating a situation where it will be for the benefit of the employee to ask for the employer to deduct more from their income. And I was just trying to think where that might be so. And I suppose it might be so if the revenue are saying to the employee, you haven't paid us enough tax, now please pay us immediately. And the employee says to the revenue, my employer should have deducted that, please let's use the deduction mechanism, because that may gain the employee some more time, in effect, that he doesn't have to find the money immediately himself. His employer, in the first instance, has to find the money and pay it. The employee, at the end of the day, will still be out of pocket to the same amount, but it it will suit him to a degree to have gained, if you like, a little bit of extra time by directing the revenue through the PAYE system. Otherwise, I just can't see why the employee would bother raising a complaint to the board, which is the predicate for operating this procedure. You need to find an interest that the employee has to ask the board to require the employer to deduct the right amount, i.e. a greater amount of PAYE from his income.
Lord, I have not considered all of the different situations that could bring somebody within this regulation. What I am seeking to establish is that in certain circumstances where there may be a shortfall, the relationship is not directly between the revenue and the employee in that circumstance. Because what ought to have happened, I would have thought, is that there ought to have been a demand to make that payment in that circumstance. So, now, Lord Briggs, you had asked the question, which is, how does the employer know? Right. So, again, this goes back to the circumstance that is before us. If we go to section 99(1)(b) of the Income Tax Act, there's a procedure for the employer to know. 474. So, and these are the provisions that the appellant is speaking to. It says it provides for a system that where
This is section 99.
1A and 1B. Now, I briefly mentioned section 91. And 91 is at page 467. And this addresses a situation in which there's been an over-deduction, and it says in that circumstance there shall be the excess shall be refunded as soon as practicable to the person whose emolument the tax was deducted or withheld. So this is a situation where the employer has deducted too much. 91 says it should be refunded to the person.
But how does that help you?
Well, it helps me in that there's no opposing, there's no flip side provision in the Act. That's what that's going to say next. It says what happens in the refund situation, but the converse doesn't exist.
But I mean, surely the predicate for the refund is that there is an underlying true liability of the employee to tax. And when one has worked out that true liability and sees what in fact has been deducted in respect of tax, that tells you what must be repaid to the employee. So the foundation for Section 91 is that the tax is truly a liability of the employee. Well, and the employer has deducted too much in respect of that liability.
But what I'm speaking to is, again, a clue to the drafting of the legislation, because we've already seen provisions which, my lordships and my lady, may appear to be peculiar and one-sided. And what we have now is another example of one-sided, in that it speaks to a situation where you refund something to the employer or to the employee, but it doesn't give provision to make a demand of the employee when the converse is true.
But I'm sorry, why isn't that covered by Section 89(1)? which was in fact the provision relied on by the revenue in this case. Section 89(1, well, as I had read it, preparing for this case, does seem to address the situation where insufficient tax has been deducted. Right. So it is the converse case.
Well, we're going to get to 89(1 in a moment. I don't know if I should get there right now, because remember, right now we're in proper construction, so we're going to get to 89(1 because this really is the substance of the case. And our position is that there is a procedure to be followed in 89(1. So if I may be permitted to get there, my lord, because I will address that. But if you would like me to address it right now,
No, you follow your course.
Okay. Thank you, my lord. So, I believe, yes, right. I was now going on to where we actually start to apply some of the provisions. So we'll get into that stage. So, Unilever case, the Court of Appeal held that Section 99 created its own exclusive and special code of taxation for emolument income. I invite you to turn to the analysis of Justice of Appeal Raj Kumar at Electronic Bundle 978. And specifically, to read paragraphs 43 to 46. The paragraphs I would highlight in particular are paragraphs 44 and 46. He says, the words, notwithstanding any provisions of this act to the contrary, were sufficiently wide to cover the assessment provisions in sections 83 and 89. And paragraph 46, he concluded that it created a special and exclusive code. So in the appellant's case...
But I'm so sorry. If you look at paragraph 47, I think that explains why the court was addressing the question in that way. As I understand it, what was an issue was whether before one made a demand of the employer to make a deduction under PAYE, there had to be a separate assessment of liability of the emolument earner. And paragraph 47 is the conclusion that the court arrives at, that no, you don't have to go through that process before the PAYE mechanism can be required to be operated in relation to the employer. That was what the case Unilever ultimately held. But there are a number of statements of law of what the PAYE regime is. And I'm quoting what Justice of Appeal Raj Kumar says it is, as an exclusive code.
Well, that's what I struggle with, because he bases this on the opening words in 99, notwithstanding any provision of this act to the contrary. So that may mean that you have a self-contained code. It doesn't mean that that is not exclusive of any other regime, but it may be that the code itself is an alternative means of the recovery of tax. I don't see how those words can support a necessary conclusion of exclusion.
My Lord, I'm not sure if what you're saying is that Justice of Appeal Raj Kumar may have erred.
Well, it depends what he may be simply be saying that it excludes the necessity of an assessment. Because it's self-contained.
The whole judgment, he clearly is saying that. He's not for a moment suggesting that there isn't a regime for the assessment of individual employees to tax and collection of tax from them. In other words, the use of the word exclusive does not mean it excludes all other means of recovering income tax from employees.
It really means self-contained.
Yes.
Okay. I don't need to press this point at this juncture. So, the PAYE regime, we refer to the code that Justice Appeal Raj Kumar speaks to as the PAYE regime in our case, electronic bundle, page 301 and paragraph 24. And we distinguish that from the regime which generally applies and that is referred to as the self-assessment regime. So I invite you to look at paragraph 24 of our case at this point, which is at page 301. Now, the headline points, really, if one compares A and B, if you keep scrolling, because he said there's the PAYE, and then, the first one is self-assessment, and the other one is the PAYE regime. The headline point, really, to be made here, now I have a useful chart in front of me, but I recognize you don't have it. So I'll try my best to articulate what is before me. So what we have is 3 stages of Whitney.
We have that chart at page 301. Is that the chart you're talking about?
Do we have it? No. Right. So I'll try to explain this, what is before me. So at Whitney stage 1, you have section 79.1, for example, and section 79.1 speaks to quarterly payments that the taxpayer makes. That is what happens in the regular regime. In the PAYE regime, the equivalent provision is section 99.1. That deals with employers deductive. It traverses the same territory, so that is the equivalent in the PAYE regime.
Why do you say that is stage 1 of Whitney?
Absolutely.
Because stage 1 of Whitney is simply determining which persons and what property are liable to tax. And that's really section 5.
I recognize, I suppose what I'm saying here is this, is the assessment stage machinery.
Yes, there are 2 different stages, and you'll be telling us, I imagine, that they are self-contained, and I'm not sure if that will be disputed. The question which arises is whether the non-operation of one gives rise to the possibility of the operation of the other.
And one sees section 79 is under the heading payment of tax. And again, section 79.1, as is true of section 79.7 that we looked at before, it operates on the basis of the taxpayer's own estimate, but that's with a view to getting in the tax which isn't in dispute as quickly as possible, because if the taxpayer accepts that it should be paid, pay it. But that's not saying, and you only have to pay what you estimate for yourself. That's just an early collection mechanism.
Payment on account.
Yes.
It's not a determinative of liability.
My Lord, in the interest of time, I would just, because there are 2 issues. So there's the recovery issue and there's the assessment issue. And the assessment issue is dealing with the validity of the assessment. And I certainly would like to be able to finish my submissions on the validity of the assessment, if I may.
Please continue.
Thank you, my Lord. So the headline point that I'm really establishing here is that stage 1, payments on account, 79.7 is in the self-assessment regime, and 99.1 is in the PAYE regime. At stage 2, you have section 89, which deals with assessments. And in the PAYE regime, you have 99.1 sub A. I mean 1A, 1 capital letter A in brackets, which is an equivalent provision. Also,
Equivalent to what, sorry?
oh, sorry, the additional assessment provision, section 89. Also, at stage 2, there is section 86, which is the notice of assessment, whereas in the PAYE regime, there is at 99.1 big B, capital B, you have service of the determination, which is an equivalent to the notice of assessment. Then at stage 3, in the self-assessment regime, you will have section 81, which deals with recovery. And then the equivalent in the PAYE regime is section, again, back to section 99.1 uppercase B, because it covers it all in one way. There is a demand, which is the equivalent in that regime, and also which is supported by section 99.4. So I'm just saying that in both regimes, there's equivalent provisions traversing the same territory. Right. So issue number 1, which is what I'm primarily dealing with right now, we're talking about assessment. Right. Right. So we're at stage 2, and we are talking about assessment. I would, if we still have the electronic bundle reference, which is at page 474, I just want to establish, if you've, to refresh in terms of exactly what those sections speak to. There's a circumstance that they speak to. They speak to, specifically, again, if a question of emolument is in dispute, or the board is of an opinion that an amount is an emolument, such as a benefit in kind, and that the correct taxes have not been deducted or withheld. So it speaks to those two situations. In other words, there are specific provisions that cover the very facts of our case. And just for your notes, and I will not take you there, but I will give you the reference. Regulation 8 of the Employment Regulations effectively repeats what's in section 99.1a, and this is at page 557 of the electronic bundle. So, the revenue is therefore obliged, the operative word being shall, issue a notice of determination on the employer in the circumstances that are set out in 99.1a, 99.1b. Now, at this point, I'll point out that nowhere in the revenues case have I read why it considers it appropriate to ignore sections 99.1a and 1b in order to quantify Mr. Monteil's emolument income. That issue seems to be completely omitted. So now I want to apply the principles that are common principles to these provisions, the provisions that are around. So if we go to section, there's 2 assessment provisions essentially. They're 83 and sections 89. So I want to apply the principles of statutory construction that we've discussed to here. So, in section 83, which deals with original assessments, there is a subclause 83.6, which provides, amongst other things, that these assessment provisions do not derogate from other provisions of the Act. That's what it says. They do not derogate, and that is pages, the assessment provisions is 80 yeah, find 83.6 for me, please. 461 is where 461. Nothing in subsections 1 to 5 shall be construed as derogating from any other provisions of this Act. That is at page 461. I respectfully submit that that includes section 99(1)A and 1B. By contrast, obviously, by contrast, just using Unilever language, that regime starts with notwithstanding any provision of this Act to the contrary.
Which regime?
The section 99.
99 regime.
Right. Yes.
And again, just whereas, just to be clear, at paragraphs 32 to 33 of the decision in Unilever, which you could find at Electronic Bundle 975 to 976, so paragraphs 32 to 33, I want to highlight here that Justice of Appeal Raj Kumar does not limit notwithstanding just to section 99(1). So he specifically includes the entire regime. I recognize time is running, so I will zoom through it. So let me just be very quick on this. So 83, if one looks at 83, at the provision that would apply if you disagree with emolument income, it uses the language may. So there isn't even an imperative that you have to do an assessment under 83 2B. It says may. Whereas in the same situation, 99(1)A and 1B say what you shall do in that situation. So 99, respectfully submitted, 99(1)A and 1B are the specific provisions for quantifying emolument income. And the assessment and the 83 is the general provision which is presumed to give way insofar as it relates to quantifying emolument income. And now let's look at section 89. 89 is at 466, and so I will rush through. Similarly, it uses discretionary may in circumstances that shall is used in 99(1)A and 1B. So again, 99(1)A and 1B are the specific, and 89 is the general. And so in our view, the section 89 can only at best be used in respect of allegedly underdeducted tax on emolument income once the procedure beginning with section 99(1)A and 1B is followed. And I submit that this is consistent with the terms of section 89 itself. So here I'm addressing a question that you had asked me before, Lord Sales, that I promised I'd get back to you. Section 89 is, okay, 466, right. Right, so I would like to take you to page 466, and let's examine what 466 speaks to. So, I have highlighted on my copy, after the first comma from where it says where, all the way to the beginning of the fourth line where it says charged. Now, where it appears to the board that any person liable to tax has not been assessed or has been assessed at a less amount than that which ought to have been charged, which is one of the triggering of this section, I submit that traverses the same territory as section 99(1)A. where there's an emolument income review process. So I submit that Section 89 is suggesting, in a situation like that, it's not mutually exclusive or to the exclusion of, says, well, there's a process when it comes to emoluments, how you're meant to treat with it. And then, at the very bottom, it says, other proceedings, sorry, no, this is the third to last line. It talks about, other provisions that apply. It says, other provisions, I've highlighted that, and then the last 6 words, and to the tax charged thereunder. And I submit that that could be read as including sections 99, 1B, 1C, and 1D. So the assessment within an assessment argument does not involve, well, it's part of the Section 89 procedure. And it's consistent that is consistent with the Reynolds approach, which is to correlate sections if you can, as opposed to treating them as if they're not to be done. So let me now...
Well, sorry, can I just ask you on that? Aren't these provisions, Section 89 as against Section 99, dealing with different matters and different liabilities of different people? So Section 89 is dealing with the liability of the employee himself. But if you look at Section 99 1A on page 474, that's only applicable if a question arises as to whether an amount is an emolument in respect of which tax shall be deducted or withheld pursuant to this section, i.e. by the employer. So I'm putting this to you so you can comment. Section 89.1 seems to be dealing with the liability of the employee, whereas Section 99.1A and 1B seems to be dealing with the liability of the employer under the tax collection regime in Section 99.
I submit, if we look at Section 99.1A, particularly subsection C, it just says where the quantum of the emolument is in dispute. That's what it says. It doesn't limit the context to it, and it says, and 1B says where the board is of the opinion that an amount is an emolument and that the correct taxes have not been deducted or withheld.
But just on that, isn't the context of little c there what is said in little a? Because you need to cover both, whether you're dealing with something is in the character of an emolument, but also how much it is. So shouldn't they be read together?
Well, I see them as alternatives.
I see. Thank you.
Right. So I'm just going to rush through. So the short point is, shall trumps may, not derogate from is subservient to notwithstanding. Now I just want to go through the practical effects very, very quickly. I see we're out of time.
You can use up part of your reply time to complete your principal speech.
Thank you, my lord. So one of the first things that I want to point out is that there is no concept of an under-deduction. I will just say this at the very highest level. There are two types of declarations that one can say exist. There is the return, and then there is the other thing that's defined in the Act as a declaration. What employees do when it is defined as a declaration, and this is in section 98(1) of the Act, that declaration is where an employee says what his or her allowances are. It doesn't speak to income. The point in this case is that they're saying that there was income, benefits in kind. So the declaration that the Act speaks to is on the expense side, it's not on the income side. The employer provides the information in respect of that. So that's, again, I'm just passing through very quickly. When the employer provides TD4 certificates, which is of the income, the employee does not sign those. And just a quick note that if you go to the electronic bundle at 15 to 20, you will see that that is not something that the employees ever sign. And when we look at the tax return, that's the other potential type of declaration. And if you were to look at the tax return, and this is another point, and the tax return here is at electronic bundle 11, you will note that in the income, emolument income side, okay, I'll take you to it, to electronic bundle 11. This is box 1. Right, so box 1, you will see here where it says income from emoluments or from employments. It says as per TD4 enclosed. I find that's an interesting statement, and the reason why that's an interesting statement is it doesn't say income from employment and then just attach applicable TD4s, etc. It doesn't say that. You are directed to put down what is on the TD4s, and the TD4s is what you get from your employer. So there's not a question of discretion there. You're told what to do. There's no other box to provide some self-estimate. You are directed what to put there. So respectfully, the question of under-declaration that my friend suggests doesn't exist. So now I just want to quickly touch on 3 practical problems with the absolute discretion approach that is submitted by the revenue. 3 problems. 1, it places an impossible burden on employees. 2, it penalizes employees for the employer's defaults. And 3, there's a potential inconsistency with the objection appeal process that exists in the Act. So dealing with number 1, impossible burden on employees. A scheme that requires an employee to challenge sums deducted or withheld by the employer because the revenue may in the future consider those sums to be emolument income is impractical, because the employee cannot know the revenue's mind. And in the Unilever case, it also shows that the employee doesn't have all the information that the employer has. In that case, just briefly, the issue there was, again, benefits in kind, like in this case, and it was the use of vehicles for private use. The employer certified, the issue was the rental cost of the vehicles and also the value of maintenance costs. The revenue concluded that maintenance costs, for example, were emoluments. How could an employee in practice know the value of the rental, much less the maintenance cost, and be responsible for that? It's unlikely Parliament intended to put the administrative burden on the majority of the population in Trinidad to work that out and to double check their employees and the state itself in those circumstances. That is not efficient collection of tax. Number 2, penalizing the employee for the failure of the employer. In our circumstance, we've pointed out that right now interest stands at 37 million. And this interest started from the date expected a return to be filed, and the only time Mr. Monteil knew about it was when essentially the revenue took this position that it wasn't properly deducted by the employer. Because remember,
when the dispute arose, could he have paid the tax without prejudice to getting it back in due course if he was right, and therefore avoided the interest mounting up?
Potentially, that situation could exist if he paid it. The thing in Trinidad and Tobago, it's a matter of public record, paying refunds is a very big issue over there. The government has taken up bonds and all sorts of things, and people don't get their refunds. It's a problem. And this is $12 million we're talking about.
So you say that if he had said, I dispute this, but I'll pay it over now on the condition you give it me back, in Trinidad there would have been a concern about whether he would ultimately have got it back.
He would have. There would have been an issue, and still, and in our case, this was back to 2012, and now we're in 2024, and this matter still hasn't been resolved. That would be the implication of him being out of pocket for that period of time as well. So this...
But sorry, if he has the option of paying it to protect himself against the interest rate, then it's just a question of him, if he decides not to do that, taking the risk that he might lose at the end of the day, and his interest may be payable.
I'm just saying, okay, we have to assume he has the money to do it. That's one thing. But what I'm saying is, but if he did, then yes, interest would not accrue. But then the issue is, when, if ever, would he get it back?
Right, but he would have a claim against the state. I mean, I heard you say there's an issue about whether the state pays, but the court process would make the state pay if the state didn't do it of its own accord, wouldn't it?
I will not press the point, my lord.
Okay, all right, thank you.
I will not press the point. So I'm just saying it's a draconian result in which the employee is paying essentially for the defaults potentially of the employer to quantify the emolument. So then, as I said, another one is the inconsistency. This is the last point I'll make. The inconsistency with both the objection and appeal process. So once again, as I mentioned initially, tax appeal board proceedings are in camera, not on camera, and we don't know the names of the parties. In this process, the employer is not involved, and in the PAYE process, there is no scope for the employee to be involved in that process. Justice of Appeal Raj Kumar specifically addressed this at paragraphs 55 to 60 in the Unilever case.
You said the employer is not involved in the proceedings.
I'm saying in PAYE proceedings, if they make proceedings against the employee is not doesn't partake in those proceedings. And in this scenario, whereby it is treated as if they are, you don't have to go through this mechanism, the employer is not involved in this. You can have two concurrent proceedings going on.
But are you saying that because the appeal process is in camera and the employer is not identified other than by initials, that the employee may not be aware of it's going on?
It is possible, but if the employee has left the company, if it's years later, they won't always know what is happening. It's not something they'll necessarily know. But the point is, when you have absolute discretion and things happen in independent silos, you can have two separate proceedings in respect of quantifying the same emolument income.
You mentioned two paragraphs of Justice Rajkumar's judgment in Unilever. Could you repeat the paragraphs?
Right, they're paragraphs 55 to 60.
55 to 60.
Yeah, and they are Electronic Bundle 983.
I won't take it to them. We can look at them later, thank you.
Okay, great. 983.
Thank you.
Right, so then you have this scenario where you have two appeals asking the same question about the same income. Was it emolument income? But absurdly, these appeals can proceed independently and can produce contrary answers to the same question. A more coherent scheme, I submit, is the one proposed by the appellant in this case. And that is, if an issue arises as to whether a given sum is an emolument, then simply put, the revenue follows the mandatory procedure set out in section 99(1)A and or 1B, and that is the exclusive forum for determining the dispute. If that is done, these issues don't happen. So, in conclusion, there is nothing unworkable about what is being proposed by the appellant. Statutory principles of statutory interpretation, when applied, shall versus may, notwithstanding versus not derogate from, specific versus general, what is an absurdity and what is not, all point to the interpretation that is being advanced by the appellant. And I respectfully submit that my learned friend's submissions, even in terms of the declaration, is incorrect about how it works. And I submit that the respondent's case cannot be, wrong on principle, basically wrong on policy, wrong on the practice, but ultimately right in the results. And with that, my lords and my lady, the appellant rests.
Could I ask you a question? What would if the board is for you on this appeal, what would its order be?
Oh, right. So the application, I would like to take you to the Tax Appeal Board Act. The Tax Appeal Board 577, right, that's exactly it. 577 of the electronic bundle addresses this was in fact what was requested at the application stage. I would like to refer this Honourable Learned Board to paragraph 8, sub 3, sub C, sub 3, which is, we refer the assessment back to the revenue for reconsideration and reassessment based on sections 99, 1A and 1B.
And if the board were against you, what would be the appropriate order?
If the board were against us on this, remember this case has not.
It's just a preliminary.
It's a preliminary point.
So it just continues on its way, the case.
But I would submit that given that 79.7 has been, well, in the respectful submission has been abandoned, we would also submit that the appeal should be allowed on that basis, given that the Tax Appeal Board's reasoning was in specific relation to that issue, and that is part of the reason why interest is currently accruing at 37 million.
Just briefly, why do you say the assessment should be referred back to revenue? I thought it was part of your case that because these two procedures are mutually exclusive, there's no scope for an assessment if the whole of the whole of the taxpayers' emoluments are from employment. You just go down the PAYE route, which doesn't involve an assessment.
No, our case, and it's certainly in our supplemental case. What paragraph is that again? Addresses that.
What Lord Briggs has just mentioned is actually, as I understand it, what you asked for in paragraph 50 of your written case. You asked that the appeal be allowed and the board exercise the powers under section 9.5 to vacate the ultra vires disputed assessment.
Well, my lord, ultimately, it would be very good if it's vacated, if it is cancelled, but I'm just saying in the application that this came up from, at the Tax Appeal Board level, I'm just saying what we had asked for there specifically was that you do what you ought to have done and failed to do in the assessment. Because we're saying that the assessment did not cover all of the boxes, didn't tick all the boxes it was meant to tick.
But this is an assessment on your client. And as I understand it, you're saying that he's not liable for any tax.
Yeah.
What I am saying at issue number one is the assessment valid? Recovery is the second issue, so to speak. And the question, and it is the respectful submission that the assessment is invalid because it did not fulfill the criteria. But I will also point out, my learned junior reminds me, the actual assessment in our case, as is the pleaded case, and this is also referred to, is said to be an assessment purported to be under section 83 2A.
But it doesn't really matter, does it? Because on your case, the only way, you say, as I understand it, the only way the revenue can recover this tax is under section 99 and recover it from the employer. That was, I understood your case to be.
Correct.
So any assessment on you is therefore, your client is therefore invalid.
I accept that it can be invalid, but what I'm also suggesting, sorry, my lord, is that there is scope to interpret the provisions as, again, part of the criteria of an assessment. And if it is done, and the 99(1)(a) and 1(b) are applied, because there's a demand on the employer, ultimately we get back to zero in any event.
But I thought the employer was now wound up.
No, the employer has not been wound up. It's still in existence.
Well, is there a winding up order? I thought it was an agreed fact that it had gone into winding up.
Yeah.
Yes, it hasn't liquidated, but it still has assets, my lord.
No, okay. But there's still the point that my Lord Richards made, which is that if your case is that the employer is the only correct recipient of this assessment, then the assessment against your client must be invalid.
That is our position, that it is invalid. That is our position, that it is invalid. And it is invalid for, because, again, when you read section 89, even though that on the pleadings doesn't arise.
So going back to the initial question from Lord Hodge, which was the start for this, why isn't the order that you seek simply to quash the assessment?
I stand
rather than
corrected. I shouldn't be complicating this. My apologies. Certainly, that is the ideal scenario, is to have it quashed.
Am I to understand your case is put two ways? One is that the revenue can only go down 99(1)(a) and 1(b), and which failing, they must go down 91(1)(a), 1(b) before they can turn to the employee. Are you arguing both arguments or simply the first?
Yes, both.
Both. Thank you.
So they have to attempt to go down 99(1)(a) and 1(b) before coming to your client.
Correct. Which was in our notice of appeal. I took you to that at the very beginning, milady.
And what's the equivalent of Regulation 24(2) in that situation? Suppose the revenue went back to the employer, argued all this out with the employer, came out with an end conclusion after all the appeals had been pursued, that millions of tax should have been deducted and weren't. Isn't there there doesn't seem to be any provision for then the employer getting that back from the employee, or do you say there isn't any because it wasn't done on the complaint of the employee? The words at the beginning of Regulation 24(2) on page 564. Otherwise, I think if he means the employer, the end result of a conclusion that not enough was deducted is the employer has to come back and deduct it.
Sorry, I see my learned junior is scribbling away. Right. So, my learned junior has suggested that, again, there may be a common law remedy in that circumstance, even if it is not addressed in the statute.
And if they went down the 99(1)(a) and 1(b) route against the employer first, as you say they should, and the court concluded that it was, on the facts, an emolument, would that then be binding finding on as far as the employee is concerned, if they then came against the employee?
Well, I'm sure the employee again, has rights to probably object as well, ultimately. But at first instance, but practically in most circumstances, the employee would not object because 1991A feeds into 1991B, and 1991B includes a demand that the employer would pay in the usual course. So in the event that this was done, it's hard to imagine a circumstance that the employee really would complain. No, I wouldn't.
Unless the employer, having paid the revenue, pursued a claim against the employee because the employee had been enriched by the employer's mistake. But anyway, we can perhaps leave that to one side. I don't want to eat into your time.
I had no further submissions. Or should I maybe? Yeah, I think so. Yeah, I'm prepared to just rely on my written submissions insofar as the application of 79.7 and so on is concerned.
Of course, we will take account of written submissions as well as your oral submissions. Thank you very much. Yes, the board will rise briefly to consider its position. Mr. Knowles, before allowing you to develop your submissions, I wonder if I might ask a question which you may or may not be able to answer. In this case, the revenue have chosen to go against the employee rather than the employer, i.e. not to invoke the Section 99 procedure. Is there any factual background established as to why that decision was taken?
My Lord, I'm not able to say what exactly the factual background was. Perhaps I can just check over lunch. I did ask. I can say that much. I'm not sure I fully understood the answer, but that may be because I received it late.
If you come back to that after the short adjournment. Thank you.
My Lords, I can summarise my submissions as follows. Section 99 does not create an exclusive code for the recovery of tax from employees. I say that essentially for two reasons. First, that this would result in absurdity, and second, and in any event, the Act proceeds on the premise that employees are liable to pay tax chargeable to them on their employment income when that income has been underdeclared by them and not paid by the employer. Further, I say that in these circumstances, the revenue was entitled A, to assess, or rather make an additional assessment on, the appellant under Section 89(1), and B, to demand payment of that additional assessment, again under 89(1). My Lords, my Lady, I concede that Section 79(7) did not provide what you might call the mechanism for demanding payment. It simply presupposes that liability continues to exist until payment is made.
As I understand your case, it is one of several provisions which point towards the employee having a liability in respect of his emoluments to pay income tax.
A liability to pay, as opposed to a mere chargeability.
Yes.
That is our essential submission. And my Lord, my Lady, I do also add that the revenue was entitled to do this, that is to say, to make the additional assessment and demand payment, without first going to the employer. My Lords, my Lady, I didn't really apprehend that to be part of the argument in front of the Tax Appeal Board or in the Court of Appeal. But my lords, my lady, never mind, be that as it may, if the point arises as a point of law, and my lords, I say, really for the same reasons, there is no obligation first to go to the employer. There is a point on procedure which is taken in my learned friend's supplemental case, namely, it's too late now for my clients to, or for the revenue to rely on Section 89(1) as the payment mechanism. I don't think my learned friend developed that in oral argument. But my lord, just as to the procedural point, what was before the Tax Appeal Board, the one point of law or contention of law before the Tax Appeal Board on both sides was essentially this: does Section 99 provide an exclusive code for collection and payment from employees? And my client, in fact, expressly relied on Section 89. That was our argument back in front of the Tax Appeal Board. And as my learned friend points out, although the Tax Appeal Board did say that Section 89 provided the justification for assessment, it went on to say that the justification for demanding payment appears to be under Section 79(7). I accept, as I've said, that that wasn't right, but I say nothing turns on that at all. And the reason I say that is simple. We are not raising any new contention before you, or some point of law before you, or contention of law, I think is the right word, which wasn't raised before the Tax Appeal Board. And my lord, my lady, we do also say that anyway, there is a power in the Court of Appeal, or rather, whatever restrictions are imposed on the Tax Appeal Board in relation to points of law, we say are not imposed upon the Court of Appeal or your lordships. So it doesn't matter if there is any difference, if I can put it this way, in the precise sections on which we rely now, as opposed to those we relied on in front of the Tax Appeal Board. We say that can't matter. The question is, what was the contention of law, as opposed to what section did we rely on? If I could just say one or two brief things about the facts of the case. The first is this: for present purposes, and I emphasise for present purposes, you must proceed on the basis that there was indeed a very substantial under-declaration. That, of course, I fully accept is a point in issue on the facts, but for present purposes, you must proceed on the basis there was a very substantial under-declaration. Can I just show you what is said? We refer to this in our case, but it's important to see what the declaration is. And that is at pages 69 to 70, I think, of the appeal bundle, of the record, rather. Give me a moment, I think it's a bad reference. It's at page, I see what that is. It's at page 11 of the electronic bundle. And you'll see it's headed Individual Income Tax Return for 2008. I'm looking at the top. Approved by the Board of Inland Revenue under Section 76 of the Act and the Finance Act. And you'll see various boxes which are filled in type. And you'll see halfway down the page, company directors, the profession, and so forth. Then on the foot of the page, you have the tax computation section, and the various figures are filled in, landing up with a total income of, I think it's 1.38 million odd. And you turn the page to page 12, deductions, and you'll see the third line down, total net income, 1.3 million odd. Then a further deduction, then you get to unsuccessful income, rather, at 1.26 million odd. You then go down about halfway to chargeable income, 1.26 million, and then tax on chargeable income, 25%, I think of lines, whatever it is, 31,000 odd. Sorry, 315,000 odd. And then you'll see the last three boxes. Total prepayments, the 325,000 prepaid, and then 189,000 is the balance payable. Then you'll see at the foot, and I submit this is important, there's the signed declaration. I have to invest my judgment and belief, given a full and true term, and particularly the whole of the income from every source, which should say required to be returned under the provisions of the Income Tax Act and so forth, given the one I have. And then there's the signature of the appellant or his authorised agent. And the reason I emphasise that is that this is a declaration as to the truthfulness of the figures. My learned friend says, and it may be a point for later on, but for present purposes, we say it is important that one must presume that this is a very serious under-declaration in deciding the issues in the case, as before you at the moment.
This isn't any kind of summary judgment case in which one assumes the facts to be true. It's a straightforward, cold as ice preliminary issue about the construction of a statute.
Exactly, exactly. But I do submit one has to proceed on the premise that this is an under-declaration, serious, on the basis, if we're right, on the underlying facts, then this was a serious under-declaration. If on the underlying facts...
Well, by serious, then you mean of a large amount?
Of a large amount, yes. Yes.
And why would it matter if it's a large or a small amount?
Well,
for the purpose of construing the statute.
I agree with that, but the fact that it is so large in my submission does give rise to what I call the absurdity argument. If it was a tiny amount, one might begin to wonder, but I agree, it's a matter of pure law. It doesn't matter whether it's huge.
Yeah, but in other, it's got to apply across the board, and other cases might be huge amounts.
Yes, exactly.
Yes.
Well, that's really my point.
But is it the revenue? Is there a discretion on the revenue, as there is here, as to how vigorously they will pursue somebody the tax?
My lady, I'm not able to answer that. I can make inquiries. All I can say is from my limited knowledge of this particular part of the law in Trinidad and Tobago, it doesn't seem, there are cases when it doesn't seem to be so aggressively pursued as one might expect.
But it doesn't...
It doesn't seem to be as aggressively pursued as one might expect in the UK.
Which is suggestive that they do have the discretion that my lady was asking about. One might
I have no reason to suppose they don't have a discretion in the sense that they must exercise their powers for proper purposes and so forth. Whether they ever, as it were, just say to themselves, well, I can't be bothered to recover this, or I feel like not recovering it.
Well, it's not whether they can be bothered, it would not be fair in these circumstances to pursue it.
And there can be resource issues as well. That's common for the revenue in this country, to decide that a claim is not worth the candle.
Yes. I've no reason to suppose that isn't the case, but I'm not in a position to say.
Would that be a convenient place a point at which to adjourn?
Yes.
Thank you very much.